Okay, welcome everyone. My name is Roberto Berto, and this is Gowling WLG's webinar providing an overview of government funding programs for US-based businesses operating in Canada and the United Kingdom. Government programs are changing swiftly, and every jurisdiction has its own unique response. So for cross-border business, certainly unique challenges, and it's always a moving target. So we're going to do our best to provide a snapshot today of where we are in terms of these programs. Before we get too far down the road, I just want to introduce our panelists today. Colin Green is a corporate tax law partner in our Ottawa office. He assists his clients in pursuing their corporate objectives, both tax-driven and otherwise. Colin's been making social distancing work by exploring the surrounding area's best hikes whenever he's permitted to do so. Stefan Smaktunovic is a professional support lawyer in our London office. He is highly experienced in banking and finance law with a focus on transactional work. He writes and delivers trainings for banks, financial institutions, private equity houses, corporations, and industry bodies. Stefan has been making social distancing work by putting some new guitar strings on his guitar. Jonathan Chamberlain is a partner in our London office. He practices employment law, working with clients of every size and at every level. Jonathan has been coping with COVID quarantine by baking lots of bread and then walking off the calories in Warwickshire countryside. So it's a very scenic experience for Jonathan. We're all jealous of that. My name is Roberto Alberto. I'm located in our Ottawa office. I practice in all manners of litigation with a focus on real estate development. For law school, I attended a joint program of the University of Ottawa and Michigan State University College of Law. So I'd be remiss if I didn't say go green, and perhaps we lost some University of Michigan grads at that point, but I've been coping with COVID quarantine by mercilessly walking my two small dogs. So they are getting sick of me, but it's still fun. This may be an introduction for some of you to Gowling WLG. We're a global firm with offices in 19 cities across 9 countries, over 1,400 professionals worldwide. A few housekeeping points. The slide deck and this webinar will be posted. So usually within a week for the materials to get up on our COVID website. Lots of materials on the COVID website as well, so we encourage you to check that out. If you have questions throughout, please use the Q&A function, which is at the bottom of your screen. Note that the chat function has been disabled. We'll do our best to answer general questions at the end, sort of time permitting. We will be answering fact-specific scenarios, but happy to engage in discussions with you if we can be of assistance. Our contact information is included at the end of the slide deck and is also available on our website, so that's also available. In terms of our agenda, on the next slide, we're going to cover a lot of ground today. Colin will speak about 2 of the federal programs in Canada, the wage subsidy and the emergency response benefit, and I'll speak briefly to risk management, and then Stefan and Jonathan will speak about the various funding schemes in the UK. This program reflects our best information at this point in time, but as I said, this is a moving target in terms of programs. Things keep changing every day, so additional due diligence is recommended and required. Next slide. So you're seeing a webinar from a law firm, so clearly you're going to see a legal disclaimer. This is not legal advice. There will be unique circumstances, and certainly you need to contact qualified legal counsel in appropriate jurisdiction, but it's current up to June 16th, 2020. But please do, keep up to date and make sure that you're looking at the source of information because everything is changing. With that, I will turn it over to Colin Green.
Good morning. Slide, please. Okay. So as indicated by Roberto, what I'm going to do is provide some brief overview with respect to the scope and structure of programs that are out there for US parent companies predominantly that are operating in Canada, generally through a subsidiary, a Canadian subsidiary, but that's not necessarily required. And we've seen an extremely broad array of programs that have come through, really that were not anticipated. And these programs are predominantly in the form of government funds and subsidies, but they do extend beyond that. And here you'll see on the slide that there's an overview in terms of measures the government have taken. The fundamental one we'll be discussing is the Canada Emergency Wage Subsidy, CEWS, in addition to the Canada Emergency Response Benefit, CERB, And then there's a variety of other programs which we won't have time to delve into today, but I will speak to them briefly just so that attendees are aware of the general architecture that's out there between subsidies for employees, for independent contractors in the gig economy, work sharing for looking to reduce the scope and burden that employers are taking by maintaining employees when they don't want to be at full employability for fiscal purposes. Work sharing, in addition to that, there's commercial rent relief. There are emergency business loans that are advanced out depending upon the scope and size of the participant. And then lastly, there's also extensions to various tax deadlines in terms of filing and payment timelines. So really a, unparalleled, at least to this juncture for what we've seen before, range of support mechanisms introduced by the government. So let's take a closer look at the first two, because these are generally the starting point that we circle in at and probably would find to be the most applicable for US entities operating in Canada directly or through a subsidiary. Slide, please. Okay, so let's talk about CEWS. Initially, when the COVID crisis started to emerge, we saw what we would have expected from the government in the form of an announced 10% wage subsidy. But it quickly became apparent that this was going to be in no way, shape, or form sufficient to provide the coverage that was necessary to forestall the biggest economic drop of employment that we've seen since the Great Depression. And frankly, without CEWS as a program, forecasts have indicated that it could have been significantly worse in terms of the scope of unemployment. So CEWS is different from what was announced in form of the initial wage subsidy and was expanded upon. And in a parameter basis, CEWS is a cash subsidy paid by the government to employers, effectively to maintain employment, to make sure that they're not terminating employees. And this is different from what was initially presented as a reduction of payroll remittances, which is obviously a lot more limited in terms of saying, we'll reduce the amount of money you have to pay us. Now the government is flat out reaching out into its coffers, and providing significant capitalization to employers to maintain employees. Eligible employers are able to apply for both CEWS and the previously announced subsidy. In fact, the subsidy will apply first and then CEWS. But from a mechanical position aside, in a big picture sense, the assistance that is provided is significant. If you receive assistance subsidies for the 10% wage subsidy, that is counted against the CEWS amount that the government pays you. But still, big picture, you're receiving a significant portion, 75% wage subsidy in certain instances. Slide, please. Thank you. So in terms of the key differences we've talked about, the 10% wage subsidy was limited in application. It provided a maximum payment amount per corporation of $25,000. And in terms of that, that's minimal, right? In terms of the application that would apply. CEWS, by contrast, does not have a maximum per employer. So this can apply virtually if you have 20,000 employees, if you meet the other criteria of the program. So it is much broader in scope. It's projected as being an $83 billion program in terms of its application all the way through, but it is still evolving. So we don't know what the final form for the later months of the program or application requirements or scope of payments will look like. It does measure thus far, though, as one of the most significant and most rapidly assembled social infrastructure programs that Canada has ever rolled out. So as discussed, if you qualify for the 10% wage subsidy, you automatically receive it, simply reducing the CEWS component that you receive by 10%. Slide, please. So eligible employers are given a temporary wage subsidy, as we work into the mechanics, of 75% of the remuneration paid for up to 3 months. That's $847 per week per employee, or 75% of the pre-crisis remuneration for the employee. There are some nuances for non-arm's length employees, but let's put that aside and work to the big picture right now. What's interesting here is that if you have reduced employee salaries by 25%, you could be in a position where you are effectively receiving 100% of the coverage from the government subsidies. Equally, there's additional wrinkles that could be used for this in terms of providing some form of working notice if you wanted to elongate the period of time before you terminate an employee. To be clear, the intent of the program is not to facilitate termination of employees. In fact, even if you're not able, if there's no work, for example, available for employees, in those scenarios that the employer is not working, the government will even pay the payroll remittance portions that employers are otherwise required to pay. This would functionally bring the cost of the employees to near zero. So the aim and intent of this program is to let companies maintain full employability all through what was projected to be and hoped to be the worst portions of the crisis. This subsidy for the wage component, CEWS, is backdated to March 15, 2020. Slide, please. Again, as we discussed, non-arm's length employees are limited to the 847, but for all other employees, there's structural flexibility in terms of how we work with this. Slide. In terms of eligible remuneration, the employees must be working in Canada, as we discussed. This includes non-arm's length employees, and employers are permitted to bring employees back to work if they've been retroactively terminated. And it includes all forms of salary, wages, remuneration, but excludes severance pay, value of stock options, and non-cash benefits. And again, if you're dealing with an independent contractor, we will discuss CERB, the gig economy portion, payments separately from CEWS. Slide, please. Again, one of the key points to highlight here is that there is no overall cap to the quantum that can be claimed by the employee. This is significant in terms of its scope and application. So really, the larger the company, the more they have potentially to gain from the benefit from it. CEWS remuneration, again, paid through to the employees and does not extend to independent contractors. Slide. CEWS is available to any form or type of employer in Canada, whether individual, partnership, corporation, and there's extensive components through. Here, from a US perspective, if you're operating as a registered branch in Canada, that's sufficient, or if you're operating through a subsidiary, that's sufficient. We have seen certain examples where US companies are operating without a permanent establishment in Canada and without delving into all the nuances on this. The key takeaway is that if you're registered for Canadian tax purposes, you are generally able to apply for CEWS if you meet the other requirements. Slide, please. Qualification-wise, employers need to attest to a reduction of gross revenue of 15% for March and 30% for April and May, compared to the same month for 2019, or an average of January, February 2020. Now, again, note that there's incredible flexibility here as to which month you apply to. Are you looking for the initial month? Are you looking for the average of January, February? There's also flexibility as to whether or not you deal with this on a consolidated basis or not, and in addition as to whether or not you deal with this on a cash or an accrual basis. So this program was really set up to try and let people qualify, to get them into a qualification scenario. Again, the program is structured to run through the end of August, and employers are encouraged to make best efforts, but not required, to top up employees to pre-salary levels. Slide, please. In terms of applying, it's generally best to practice through by applying through the CRA My Account business portal. We have seen times of 2 to 5 weeks in terms of applying, but you are able to apply retroactively. Slide. As discussed, CEWS will be included in the employer's income, but the deduction correspondingly will be provided for the payment through to the employees. So it's effectively tax neutral for for employers in terms of the receipt of the funds and the subsequent payment out to employees. Slide. In terms of employers, they would need to ensure that they're registered with CRA for direct deposit, and they should assemble the records to demonstrate and prove the 30% reduction for the subsequent months' gross revenues. I'd also note that once you qualify for one period, you automatically qualify for the subsequent month period. This is a month-by-month application. Slide, please. From a government consultation perspective, we'd note that they've announced consultation period that closed June 5 for, quote, structural changes to the program, but have no details as of yet as to the manner or form that these changes will take. Slide, please. So I'm going to provide some very brief comments as well on CERB. The anticipation is that this would be less helpful to a US employer with employees in Canada. It is something, however, that employers, US included, should be aware of if they're operating with independent consultants or gig economy practitioners in the Canadian scope market. Effectively, CERB provides a $500 a week payment for up to 16 weeks. Now, we're nearing the closing end of this program window. However, people are able to apply retroactively. Slide, please. These benefits are taxable. In addition to that, we note that in order to achieve these benefits, you would need to indicate they have to provide an attestation that they have stopped working because of COVID-19 or otherwise eligible for employment insurance. They have to have had at least $5,000 of Canadian sourced income in 2019, and they have to expect or to be without employment for at least 14 days. Slide, please. The $5,000 requirement is met fairly easily from a broad range of government sources or independent economic sources of reported income. Slide. Again, the CRA My Account site is used and recommended for application purposes, but it can be done very easily and quickly. Slide. That concludes my presentation.
Great, thanks, Colin. So just moving on to the risk management element. Certainly risk management is part of any decision-making process for any business, and this includes potential enforcement from the Canada Revenue Agency. Abuses of these federal programs have been gaining a lot of traction in terms of media attention. Even last week, Justin Trudeau's minority government was unable to pass some new penalty provisions in relation to CERB, and there's even some discussion about extending it as opposed to moving on a penalty state. So it's a moving target in terms of the penalties. But from a high level, it's helpful to understand the distinction between tax planning, tax avoidance, and tax evasion. Tax planning is a reduction strategy that meets the specific wording of the legislation as well as the spirit of the legislation. Tax avoidance meets the specific wording but does not meet the spirit, and so there can still be penalties in relating to tax avoidance. So people like call and provide tax planning avoidance, so you avoid tax avoidance penalties. And then tax evasion is the more overt use of gross negligence or intentional acts, and it comes with higher penalties and notably the potential for prison time. As a note, there is no privilege that connects in terms of correspondence with accountants when you have questions about tax planning versus tax avoidance versus tax evasion. So if there's a risk there in Canada, solicitor-client privilege does attach to discussions with tax lawyers. So something to consider if there's any gray area or uncertainty there to make sure you're getting the right advice without putting with it while minimizing your risk. Next slide. And so the tax avoidance penalties are punitive typically with penalties from 50% to 200%. And again, additional fines on top of that for evasion and the risk of prison time. Next slide. With respect to monitoring these programs, for CEWS specifically, the CRA is using a combination of automated queries, a third-party complaint line, or a snitch line as the media is terming it, follow-up phone calls, and then post-payment reviews or audits. Now, in terms of the post-payment reviews or the audits, the scope of that is unclear. CRA has helpfully said, we'll figure it out later. So again, important to have your ducks in a row to minimize risk. The employer will be required to repay amounts paid under the subsidy if they do not meet the eligibility requirements after the fact, as well as penalties. Next slide. And then, so the CRA expects that you're maintaining adequate records to support your claim for eligibility, that assumptions are included in those written records, that the nature of the remuneration is considered and documented, and maintain a signed attestation and records of any elections, just so that you've got all your documentation in a row in the event that there is an audit after the fact. Next slide. For the anti-avoidance rule, it will be 25% of the wage subsidy as a penalty on top of repayment of the wage subsidy. And for gross negligence, it's at this point, it's 50% on top of repaying the wage subsidy. So significant penalties there if you're found to be offside after the fact. Next slide. So as I said, there's been a lot in the news about the penalties and what that's likely to look like. So I'll speak very briefly to some of the penalties, but noticing that, you know, legislation seems to be coming hard and fast. And so this does appear to potentially be a moving target. Next page. So there's recently been rhetoric about a more aggressive approach. CRA's portal is open for complaints. And again, that's sort of the snitch line as well that was referred to for CEWS. The approach for this legislation was to just get the money out as quickly as possible and worry about it after the fact. So, you know, where the penalties are after the fact, you know, it could very well be a moving target and is likely to be so. With that, I'll pass it on to Stefan.
Thanks very much, Roberto. Good morning from the UK, everybody. Next slide, please. So in this part of the session, we're going to look at the UK government's bank funding schemes that may be available to US entities who have a footprint in the UK. We'll have a look at those schemes in a little bit more detail in a moment. We'll look at the main eligibility criteria, some of the key restrictions around accessing those schemes, And also, I thought it would be useful to provide some practical points if you're thinking about accessing some of those schemes in the UK. Next slide. So what are the main schemes? So we have 4 main schemes in the UK on this slide. The first one is the Coronavirus Business Interruption Loan Scheme, which we call CBILS, for avoiding a bit of a mouthful with that one. And that's really aimed at businesses with a turnover up to £45 million, so really the small to medium enterprise space. And the funding limit on those schemes is £5 million. The next scheme is the Bounce Back Loan Scheme, which is a much smaller scheme in terms of funding limit, a maximum of £50,000, but it's available to businesses of any size, so good if you're looking to get a quick injection of cash very quickly into the business. The third scheme is the Coronavirus Large Business Interruption Loan Scheme, which again we abbreviate to CLBILS to make it a bit easier. That's aimed at slightly larger businesses, 45 million plus. And on that scheme, we have a funding limit of £200 million. And then finally, we have the COVID Corporate Financing Facility, CCFF, which is really aimed at investment grade rated businesses. And the funding limit on that, depending on the actual investment grade rating of the business in question, is up to £1 billion. I thought it'd be useful to put these schemes into a bit of context in terms of actual lending that we're seeing against these schemes. So by far the widest used scheme at the moment is the Bounce Back Loan Scheme. That has something like 863,000 businesses using it at an average of £30,500 per business. The second most used scheme is the first scheme, the CBILS scheme, and that has at the moment 49,000 businesses that have been approved, and the average lend on that is 205,000. Obviously a bit less than the 5 million limit suggested by the scheme. Then as we move to the larger schemes, the CLBILS scheme at the moment has 279 facilities that have been granted, an average of 6.34 million per facility. And then finally the COVID Corporate Financing Facility for investment grade businesses, which has a lower limit as you'd expect, but we have 165 approved businesses and 55 have drawn, and we have about 16.37 billion outstanding. But overall, across the 4 schemes, there's approximately 109 billion of available credit that has been made available, so quite big sums. Next slide, please. So if you're looking to access these schemes, when are they available till? So the first 3 schemes, the CBILS, the CLBILS and the Bounce Back Loan, pretty much available until mid-autumn, September to November. There have been some mutterings from the UK government that these schemes may be extended to the end of the year, but I think that's probably going to depend on how well the UK government and the UK economy rebounds from all of the COVID crisis. The CCFF scheme is available for a bit longer, till March 2021, which is good news for investment grade businesses. And then in terms of the kinds of facilities that you can expect to see on these facilities, the first 2 facilities, the CBILS and the CLBILS, it's a wide range of financing really, term loans and revolving credit, asset-backed finance and invoice finance. And the terms of these facilities really vary from 3 years to 6 years in length. The smaller Bounce Back Loan Scheme is available for 6 years, but that's term funding only. And then on the COVID Corporate Financing Facility, that's a 12-month scheme, and that's a commercial paper scheme, so corporates will issue commercial paper, usually via their funders. Next slide, thank you. So let's look at these. Let's take a look at these schemes in a little bit more detail to understand how a UK footprint of a US business might be eligible. And we'll take a look at the CBILS scheme first. This is the facility that you have a 5 million facility limit on potentially. And the first criteria is that the UK must be UK based in business activity. What does that actually mean? Well, it means that the business has to be trading in the UK, not just sort of selling into the UK. And really the core business operation has to be within the UK. So in practice, that's probably going to mean UK incorporated businesses that a US owner might own or have a share in. It may extend to branch businesses, but again, it depends really what core operations that branch has in other jurisdictions. So if the main business operations are in the US, then potentially it may not be eligible. So that's something to bear in mind. Once you've looked at that, that the business has to actually generate more than 50% of its income from the sale of goods or services, but that can be export-based as well. So if you have a UK business that is principally exporting, then potentially that's eligible too. The next thing is the turnover threshold. So I mentioned earlier that the turnover threshold on the CBILS facility is 45 million. How do you actually assess that? Well, it really depends on the ownership structure of the UK business. So if you've got a UK business that has not more than 25% ownership by any of the shareholders, and the UK business doesn't have a 25% or more shareholding in any other business, then it's deemed to be a sole enterprise. And that means that you assess turnover on the turnover of the enterprise itself. Where you go above that, if you've got a wholly owned subsidiary or a majority owned subsidiary structure, then you're really looking at the group turnover when assessing whether or not the turnover is 45 million. Anything between the gaps, so anything between the 25% and the wholly owned or majority owned subsidiary, you're looking at whether those business partners, each of the shareholders in the business, has any other linked enterprises, so any other sort of majority or whole subsidiaries, that kind of thing. And if they do, then you're going to get those pulled in. So you're looking at a group basis there. So each business is obviously going to have its own structure, and it's important to look at that when you're assessing whether or not you're eligible for the scheme. On a plus side, if you're a private equity investor, venture capital company or business angel, if you're looking at a single company, you can have a stake of up to 50% rather than 25% in the business, and that may allow you to consider that UK business as a single company. But again, it may depend on whether that UK business has other shareholdings in other businesses as well. And also a private equity investor's turnover and its turnover from other investments will be excluded from the turnover calculation when you're looking at that. So that's really the turnover. In terms of other key criteria, the UK business needs to have a borrowing proposal which the lender would consider viable if COVID-19 hadn't happened. Obviously, there's a fair amount of discretion for lenders here, but the UK government is trying to encourage lenders to lend where it can on this facility. The business will have to self-certify that it's been adversely impacted by COVID-19. That may be relatively straightforward depending on the sector, but obviously if a business has been doing fairly well, then it may be more difficult to prove that, for example, if you're in the tech sector. And then the other thing that banks may want are security and guarantees to support the scheme. In our experience, some banks are looking to existing security structures to achieve that. But it may be that other additional security or guarantees are required to make the scheme viable for the lender. Next slide, please. So what about the key restrictions? Well, the turnover test is a very strict test, so it's unlikely that you'll be able to sort of tweak the balance sheets to be able to get around that. And there are certain sectors that are excluded from the CBILS scheme, which include banks, insurers and reinsurers, but not insurance brokers. There are also state aid tests that apply. So if the UK business has had any kind of state aid, there are EU rules that apply. And that may mean that the UK business can't actually get access to the scheme. Additionally, there are tests around whether or not the business was viable as at the end of last year, which are looked at in a lot of detail in the British Business Bank's frequently asked questions, which you'll see a link to at the bottom of this slide. The other thing to bear in mind is that even if the business is viable and on the face of it can apply for the scheme, each of the lenders that are accredited under the CBILS scheme are actually restricted in what they can lend in terms of their maximum aggregate lending caps. Because behind this scheme and the CLBILS scheme sits government guarantees at 20% of the lend. So there are caps on what the lenders can lend, which may be a reason why, as we see the scheme progress, that we see some of the lenders unable to lend against this scheme. Next slide, thank you. So that's the CBILS scheme. The smaller bounce back loan scheme, again, sort of similar in concept. In terms of eligibility criteria, the business has to be relatively new, be established on or before the 1st of March this year. Again, it must be engaged in trading or commercial activity in the UK. And that essentially means that it's got to be a UK incorporated company or limited liability partnership or tax resident in the UK. Unlike the civil scheme, there is no turnover test, so it can apply to any type of business. But again, more than 50% of group income has to be derived from trading activities, so another 50% test there. And also the borrower has to show that the loan is going to be used to provide economic benefit to the business. It can't just borrow it for the sake of it. And in terms of what you can borrow here, it's capped at 25% of the UK businesses turnover. Next slide, thank you. In terms of restrictions, one thing to bear in mind is that despite the relatively low facility limit, £50,000, that doesn't mean you can go back to the banks once you've repaid it and ask for another 50,000, etc., to get you up to £1 million or 2 million, etc. It's really a one-off application there, so you're restricted to the 50,000. And also, if you've got a business in your wider group that's access funding via any of the other schemes or this scheme actually, then there are restrictions about accessing the scheme. So that's something to bear in mind just in case you have a wider group in the UK or a wider footprint that's accessed other schemes. Again, we have types of businesses that are restricted, banks, building societies, etc. And another restriction here is that the business itself can't be in any kind of liquidation or bankruptcy or similar process at the time of the application for the scheme. Again, we've got state aid rules that apply, which are similar to the ones I've explained already. And again, we have a link here on the slides that will be made available following the session with some more of the FAQs from the British Business Bank on that. Next slide. So those are the really sort of the smaller schemes. In terms of larger schemes, the CLBILS scheme, which as a reminder is lending up to 200 million. Again, similar kind of tests here. The thing that I'd flesh out from this slide is that the turnover point, so turnover of more than 45 million. And again, similar assessments in terms of whether or not you're a sole enterprise, whether you're a group enterprise. And again, if you're a private equity or venture capital backed business, then those businesses are treated separately for the sake of assessing turnover. In terms of the restrictions, there are certain other restrictions that apply here. So the first one is on the borrowing limits. And you'll see that in terms of borrowing limits that apply on the CLBILS scheme, it's essentially either the double the amount of the UK wage bill, 25% of the UK business's turnover, that's annual turnover, or 12 months liquidity needs. What's not clear from the British Business Bank is whether that's an either or whether it's the maximum amount of those. But clearly that's a discussion to be had with your preferred bank if you do choose to look at one of those schemes. The other thing to bear in mind is restrictions around share payments and also senior management pay. So for facilities of up to £50 million, there can be no increase in dividend payments over the duration of the facility. So if you're a UK business or you have a UK business that's currently paying dividends, then current levels can be sustained on facilities of up to 50 million, but you're not going to be able to increase them. And that may be if the business improves. So that's something to bear in mind. On facilities over £50 million, it gets more severe because there are actual prohibitions on dividend and share related payments, and also around senior management pay rises and cash bonuses. So if you are a US business looking to extract cash via dividend from a UK business and you're borrowing more than 50 million, then you may not be able to. So that's something to bear in mind. And obviously, if you have existing facilities already, there may be other dividend restrictions and paid restrictions that apply in any event. Next slide, please. And then finally, the Bank of England fronted CCFF scheme. So this is a commercial paper scheme. And the requirements here are that you've principally got to make a material contribution to the UK economy. But that includes UK incorporated companies with overseas parent companies. So what we've been seeing in terms of the companies that have drawn on the CCFF facility is that we've got a lot of overseas names that we're seeing. So the likes of BASF and the likes of Nissan, Toyota, people like that. Are drawing under this facility to sort of help their UK-based businesses. In terms of being able to access the facility, there is an investment grade requirement, and that is that as at 1st of March 2020, you need to have had a short or long-term investment grade rating from S&P, Moody's, Fitch, or DBRS Morningstar as set out on the left-hand side of the screen. If the business doesn't have that, that doesn't necessarily mean that it's game over, because individual banks may have their own internal credit ratings on businesses, which may be able to be used if the Bank of England are happy with that. And alternatively, a business may be able to look to one of the credit rating agencies and have a discussion around whether or not they can get a credit rating. But there may be more discussions to be had with the Bank of England around whether or not that's viable in terms of access. In terms of documentation requirements, there are standard form requirements that apply here. So specimen commercial paper documents are available on the Bank of England's website. And again, if you are lending into a UK entity and essentially it's got a US parent, then the Bank of England is likely to be looking for a guarantee and legal opinion from the main group entity if it's not a UK entity. In terms of the prohibitions, these are very, very similar to the CL bill scheme. So again, we have prohibitions on distributions and senior management pay, and that's really going to be provided in terms of an undertaking from the company to the Bank of England. And again, you can't use this in conjunction with the other schemes, and there are restrictions around what types of entities can use the facility. But ultimately, the scheme is at the sole discretion of the Bank of England and HM Treasury. Next slide, thank you. So there's a little bit more information on both of the last two schemes on this slide. And again, the British Business Bank website and Bank of England website have more details. Next slide. And finally, a few practical points before I hand over to Jonathan. The first thing I'd say is to engage early with an accredited lender. So if you think a UK business would like to tap into one of these schemes, get a discussion going with the lender sooner rather than later. The list of accredited lenders are on the relevant websites. It may be tempting to shop around lenders for best price. As with any banking facilities, what you tend to find is that if you're a new borrower with a new lender, then the credit application process may take longer. So it may be worth thinking about whether or not you go to an established relationship lender to look at these schemes first. In terms of funding proposals and financial information, obviously getting together the core financial information and your borrowing application are going to be very important. In terms of the documentation that you can expect, a lot of the smaller schemes, certainly the CL bill scheme and the bounce back loan scheme, will be on bank standard form documents. So it's worth thinking about whether there are any restrictions in local documents that will prevent lending, security, any other subordination restrictions, etc. Around lending at the UK level, because you may find that the standard form documentation in the UK has specific requirements around that, and that could cause some problems later up the line, which you don't want to have. So it's worth thinking about that earlier rather than later. And then it's worth bearing in mind that although we're not seeing 100% approval ratings for all of the facilities across the board, and the banks are restricting facilities to certain amounts, that doesn't mean that you can't look to banks for other funding alternatives, and we are seeing some people doing that as well. So if you can't tap into the COVID funding, have a think about a discussion with the lender around alternatives. And there is also a UK government page, which is quite useful, which has information about a lot of the financial schemes. So with that, I will pass over to Jonathan, who's going to talk about some of the employment schemes.
Good afternoon. Well, we have in the UK our equivalent of the Canadian schemes. We have the Coronavirus Job Retention Scheme, known colloquially as the furlough scheme. Furlough is a term that's used in the US, has been for many years. It's not really a term that we had used in the UK up until now, but we've borrowed it from you. So thank you very much for that. And how the scheme works, it is a temporary scheme which is open to all UK employers until the 31st of October this year. And I'll come back to what's going to happen towards the end of that deadline in a little while. But for now, the important point to note is this. When I say all UK employers, I don't mean UK registered companies or UK based businesses. I mean any business in the UK which has a payroll registered with our tax authorities, HMRC, Her Majesty's Revenue and Customs, the equivalent to the IRS. Because in the UK, employers have to operate withholding taxes on payroll. the self-employed account for their tax in a tax return at the end of the year, but most everybody pays most of their taxes through payroll, which means that this has been a really easy scheme to operate and access. And it means that if you are a US branch or a US a subsidiary in the UK, whatever your corporate status, if you had a payroll, you could access the scheme. Now, it was also incredibly generous as to which employers could apply for it. It was any business which was affected by COVID-19, which is very, very wide. And you didn't have to prove any degree that you were affected by it or particular impact. There were no thresholds. If your business was adversely affected by COVID-19, you could claim. The main difficulty in operating the scheme is that employees can do no work for the employer whilst they are on furlough, as we now call it. And there are also administrative points, like furlough has to be for a minimum of 3 weeks. So what some companies have done is have rotating furloughs. Some employees go on for 3 weeks, then they swap with colleagues and they come back to work full time for 3 weeks, and then they swap again. As the scheme has been consistently extended, at first it was only going to apply for a couple of months. We'll come on to why it was extended in a moment, because the drivers for that are quite interesting, and there are some interesting timetables as the schemes start to wind up. And there are issues about what doing no work meant. So lots of companies wanted to communicate with their employees who were on furlough as to what was happening in the business. Did that contravene the no work rules? Well, we took the view that it didn't, and later on government guidance confirmed that was the case. Employees have been able to give evidence in court. They've been able to take part in redundancy consultations. Remember that one, because we will come back to it later. But crucially, they haven't been able to generate any value for their employer. That will change. As the scheme winds down in the coming weeks and months, we will see how that will change. But as of now, and as and when the scheme was introduced, if you are on furlough, you did no work for your employer. Now, what does furlough mean? That employers can claim up to 80% of the furloughed employee's usual wage costs, up to £2,500 a month, plus social security, payroll taxes, we call them national insurance in the UK, and certain mandatory retirement pension plan contributions, which employers are directed by statute that they have to make. They could also be claimed back. Employers were free to top up to 100% if they wanted to. Some have, particularly in professional services, for example. But most obviously didn't. And it's been fair to say, I think, that the scheme has been regarded as the most tremendous success in terms of keeping the economy afloat. About 8.5 million people have benefited from it. It's cost about 15 billion to date. These were the figures towards the end of May. And it's contributed to the fact that UK unemployment has only risen by about 600,000 since COVID-19 really started to impact in March, which is a pretty good result. However, the scheme is now being phased out, and let's look at that on the next slide, please. The first point to note is this: the scheme was closed to new entrants. Companies could not put anyone else on furlough who hadn't already been on furlough on the 10th of June. There are exceptions for people who are on family leave. In the UK, we have a statutory maternity leave system, and what's been happening is people are on maternity leave, the terms of which can often be quite generous. The the element the state pay if you're on maternity leave is not very generous at all, but many employers would top that up, and it would be worth more to somebody on maternity leave than they get on furlough. So funnily enough, they weren't furloughed when they were on maternity leave, but when they've come back, then there isn't actually a job for them to return to. So at that point, they can be furloughed, but otherwise, the scheme is now closed. So why am I even talking to you about this at all? Because this is supposed to be a webinar about which programs are available to you. And I'm cheerfully telling you that this program isn't available to you anymore. And that might now see a precipitous drop in the number of people who are staying on the webinar, but let's hope not. Because there is some important stuff that I would like to talk to you about. Because really, if you have a business in the UK, you have clients with businesses in the UK, and they have not been taking advantage of the furlough scheme when they have been able to up to now, up to before the 10th of June, then well, you've got bigger issues than that, frankly, because as I say, the scheme has been a huge success. It's been really easy to operate. The government set up a website through which claims could be made. And of course, we all thought government IT project, this is going to be a disaster. No one's getting any money. Actually, apart from inevitably the first 24 hours when it crashed under the weight, because they always do, the scheme worked really well, and people have been getting payments promptly and easily. So what we're now talking about, the situation that you or your clients will be concerned with in the UK, is what's happening as the scheme is winding down. Well, the first point to note is that you can still make claims for employees on furlough, but the total number of employees you can claim for is capped at whatever the biggest number you claimed for was before the 10th of June. So it's entirely possible, because the business cycle, you had 50 employees on furlough in April, you only had 30 employees on furlough in May. As of June, you can claim for up to 50, not 51. You're capped at that 50 that you were doing it in April. It is necessary to have a written agreement with your employees as to the terms of their furlough the terms of the furlough that they're working to. It's always been necessary, it's always been a condition, but it's now particularly important because of how arrangements can change. Because from the 1st of July, employees are able to do some work. Now, you recall that at I said that it was a cardinal rule of the scheme that employees couldn't do any work at all. The idea is the balance is now going to shift between employer and government. So from the 1st of July, employees can do some work, and if they work, then the employer pays for those hours, and the government will make up the difference up to the previous cap, 80%, up to £2,500 a month. But then over the next few months, until the end of October, then the amount the government pay goes down and the amount the employer is required to pay goes up, because the government from the 1st of August is going to require employers to pay the social security contributions, national insurance as we call them. And then in September, the government is only going to pay up to 70% of the cost up to the cap. But employers, if they have employees on furlough, are required to fund that additional 10%. They can't just take the government money and say, sorry, employees, you're not getting it. They have to make up the difference. And then in October, the burden shifts by another 10%. So you can see that employers are incentivized to get something for that money and to bring people back to work. So on the next slide, we're going to start to look at some of the practical implications of that. How is this working for businesses? And hopefully the next slide will appear. Excellent. Now, the CJRS was, when it was first brought in, with typical British cynicism, known as the redundancy deferral scheme. Let me just take a step back for a moment. We have this concept of redundancy in UK law, which is when your employment is terminated because you don't have enough work to do. And there are certain employment protection regimes which apply in those circumstances, and compulsory payments that an employer has to make if employees are made redundant. Think of it as a reduction in force program, or at least that's a way of thinking about it for the collective redundancy rules. The collective redundancy rules, a version of which applies in every country across the EU, require employers to consult with employee trade unions or employee representatives for a minimum of a certain number of days before they make the employees redundant. The crucial number is 45 days. And that is why I said I was going to mention this earlier. The scheme became extended over the summer because at one stage the government realised that big employers in the UK were all about to announce they'd started consultation on a massive wave of redundancies. The trigger is if you're going to make 20 or more people redundant at the particular establishment in which they're working. And the airlines, other transport companies were talking about making tens of thousands of people redundant. So that was why the scheme was extended. But that 45-day timetable is still going to run. It's going to be hitting us round about mid-September. In fact, it's going to bite earlier than that because you're going to need to start a consultation with the workforce, and if you don't have unions in place, they're elected representatives, you'll need to arrange the election. So that's why I've said 45 days plus. And the bad news about those rules is if you don't follow them properly, it's a 90-day penalty, not a 45-day penalty, but a 90-day penalty for failure to consult. So you need to be looking ahead as an employer to what are going to be my labour needs when this scheme comes to an end at the end of October. And you need to be starting to be planning for that now and getting ready to launch your consultation in mid-September. Now, that unfortunately isn't the only problem that you will face. One of them is whistleblower claims, and this was mentioned earlier in relation to Canada, where it's a safeguard that the government had built in to prevent abuse of the programme. And they've done exactly the same in the UK. There is a special whistleblowing hotline in HMRC, which has been ringing, if the technology was still like this, off the hook, as employees have telephoned to say, my employer is claiming furlough for me, but making me work. Employees have rushed to drop their employers in it with the taxman. And there is going to be a reckoning for that because as HMRC start to audit these claims and to see which ones should never have been made, they will be asking questions. There will be a temptation for employers to fire the whistleblower, whoever made the call, and those employees are protected by legislation. It's the equivalent of what was brought in the US under Sarbanes-Oxley. Whistleblowers are protected. They're not incentivized like they are in the US to make claims and gain a percentage of the fine. We don't have that yet. But if they are dismissed or subjected to a detriment because they've blown the whistle, they have extensive statutory protection. And that runs alongside the ordinary employment protection regime that we have for employees, the right not to be unfairly dismissed. Because as well as the collective consultation for redundancies, you have to consult individually with employees who are being made redundant, and that process can take a couple of weeks. So there's a lot of planning, a lot of work to be done as we start to wind this scheme down. So I hope it was worth you staying on the webinar to listen to that, even if the chance to make claims for some of your workforce has now passed. So that's the end of my presentation, and I think we are now going to take questions, Roberto.
Yeah, so we're about 5 minutes left, so we'll make sure that we're committed to finishing within the 1 hour. I know that one of the questions that was asked a few times was about the slides, and again, we'll endeavor to have those posted on the Gowlings COVID-19 website within the next week. One of the questions, I think, for Colin Green is talking about the structures required to participate in the Canadian programs. Colin, can you speak to that?
I'll hop right into that actually in view of time. Thanks, Jim, for your question. Thank you, Roberto, for passing it through. So, obviously we're always limited in terms of scope of application, but I will offer the following general requirement comment. When you're operating in the Canadian scheme, in the Canadian structure or sphere of tax, it's necessary to assess whether or not an entity, a corporation, individual, what have you, is carrying on business in Canada. If you are carrying on business in Canada, that comes with some fairly immediate tax filing requirements in terms of filing your return. Take the next step, and here we're working at a kind of warp highway level of international cross-border taxation. If you're operational and actually earning income within a scope of activity in the Canadian sphere, that's a permanent establishment, a PE. So to all the questions as to whether or not a UK parent or a Canadian sub or a US parent or a Canadian sub of the US parent, JV, partnership, what have you, the starting point of the analysis would be whether or not we're dealing with a permanent establishment. If there is a permanent establishment, if you are telling the Canadian government, look, we earn income in respect of this scope of profit. If there's a parent entity that's registered as a branch, same issue, that would put that entity in a position to benefit from the Canadian government programs that we're reviewing, because those programs are designed to assist Canadian employees, irrespective of whether or not they're employed by a Canadian sub or a foreign entity or a Canadian parent company controlled entirely in Canada. So in all instances, what you would do is you would go through the analysis to make sure that you have the appropriate scope and presence with the Canadian government in terms of the permanent establishment and tax and income attributable to Canadian scope profits. And then you would go through and apply the application program. So we've helped a wide number of foreign entities, gain significant benefits under the Canadian market programs that were reviewed by virtue of having that presence in Canada and going through the correct filing. So I just would flag that point because I think it's important for people. Thank you.
And I think at this point we're going to wrap it up. So thank you everybody for joining us. And if you have any questions, don't hesitate to reach out and contact us. Again, our contact information is on the slides and available online. So thank you everybody for joining.